Awesome. Okay, well, welcome everybody to the Business Owner's Plan. This is the third event in our business education webinar series presented by the Solving Chamber of Commerce in partnership and support from the City of Solving. Just a couple of quick housekeeping items as we get started. We will be recording today's webinar, so it will be available for later reference. And throughout the event, please feel free to type any questions or comments into the chat. We will be monitoring that. There will also be some dedicated time for questions throughout the event. And to do a quick introduction on our host this evening, Tamara Arnold. Tamara is the founder of Truce Resolutions, an estate planning and family conflict resolution practice built on a simple premise. The right legal guidance protects our most important relationships. As an active member of our community for the past 12 years, she works closely with families and business owners to create an actual plan to protect what works, to protect what they've built so that if something should happen, everyone knows what to do and how to step in. Tamara came to this work the hard way. She's lived through experience with early family loss, divorce, and relatives facing dementia. Her mission now is to educate and serve our community to ensure other families are prepared before their worst day, not struggling to pick up the pieces after it. Her practice is focused on ensuring every client receives a priceless gift, peace of mind. So without further ado, Tamara, take it away.
Thank you, Caitlin, and thank you to the Chamber for putting this together and for the Chamber's commitment to bringing educational and empowering events to the Solving business community. And thank you for whoever shows up tonight for making the time to be here with me. I know taking time away from your families is difficult, so I will do my best to make sure that this is an hour well spent. So this is the Business Owner's Plan, how to protect your family and your business if something happens to you. And by the end of this hour, you will know if you need a plan and why, which documents you need to create that plan, whether you can do it yourself or whether you really want to speak to an attorney like me, how you can protect your business as well as your family if something should happen to you, and the real cost of planning versus the cost of not planning. So this presentation is intended to be interactive, so feel free to type your answers and your questions in the chat. The questions I'll probably get to at the end, but there will be some opportunities for you to comment and contribute to the chat. So pull that up. And also, I may not get to all of your questions tonight, but I do want to tell you how you get your questions answered. So I'm going to put the link in the chat as well. On the screen now is a QR code. You can either scan the QR code with your phone and it'll take you to a worksheet, or I'm also putting a link in the chat so you can pull up a form that way. And that is how you get your questions answered. So that is information to me about what it is that you're seeking and how I can help you. So by the end, I'm hoping that you'll submit that form to me, and I will be making a special offer for you to take action tonight. So stay till the end, and we can get started. So I wanted to start tonight with a few critical questions. And this really has to do with why you're here tonight. If you became incapacitated or you died tomorrow, would your team be able to run your business without you? Would your income continue to flow? Or would everything come to a screeching halt, leaving both your family and the business that you've built at risk? And similarly, on the personal side, if you became incapacitated or you died tomorrow, would your family be stuck in court and conflict? Would your family know what to do and where to turn? And if you have young kids, who has the legal authority to care for them? Would they be sent to the care of strangers? So these are very serious and very critical questions, and I'm going to do my best to answer all of them for you tonight. But first, a little bit about me. I'm Tamara, an attorney with over 20 years experience, and I'm the owner of my law firm, Truce Resolutions. I was recruited out of law school to join 2 top global law firms representing Fortune 500 clients from Bank of America to 3M in multi-million-dollar class action lawsuits. And I've represented thousands of soldiers injured in combat. But over the years, as I've had my own personal challenges, the death of a parent, a divorce, dealing with dementia, and family members gone too soon, and when my family moved to the Valley, that gave me an opportunity really to reimagine my practice, because I wanted to be the kind of lawyer that helps families, not corporations. And I wanted to be the lawyer that helps families during their most serious life transitions, when they need compassionate and sound guidance the most. I have a really special job because clients put their trust in me to advise them during life's really tough challenges as their go-to personal family lawyer. And whether I'm serving as a mediator or a divorce coach or counseling family members through life and legacy planning, I take that job very seriously because I help guide families through those tough conversations. It's a trusted role I don't take lightly. So for me, this practice is not about selling documents and never checking in with you again. I want to be there for my clients, not just for this phase of life, but really for all of them. My office is right here in Solving, and I'm licensed to help clients all over California. Finally, I'm a mom in a blended family with 4 kids between us. My family is everything to me, and that's why I want to help you protect yours. I believe in excellence. My background includes graduating from UCLA and UC Davis School of Law. I'm a member of the Personal Family Lawyers Network, which is a bunch of attorneys across the country who practice like I do, heart-centered estate planning in a different way than most stuffy firms. And I'm a member of Wealth Council, the premier estate planning system to ensure that the plans that I create are state of the art, up to date on changes in the law, and custom. I don't use templates, and I don't dabble in this. When you work with me, you're getting a massive toolkit: legal strategy, conflict resolution, and excellent compassionate guidance all in one place. I'm also an active member of our community. I currently serve as commissioner of the Santa Barbara Civil Service Commission, and I'm on the Santa Barbara County's panel of civil mediators, and I'm a member of this Chamber of Commerce and of the Rotary Club. Okay, so first, some basics to orient you to what we're talking about tonight. When we're talking about estate planning, we're talking about the process of making sure that your family, your team, and your clients aren't left with a mess if something happens to you. That's the simplest way I can put it. And when we're talking about business succession planning, we're talking about the process of transitioning your business to be able to succeed and thrive without you in the event of your retirement, incapacity, or death. But I didn't want this to be too stuffy, so I thought we would start with a little game, a game that I call True or False. How many of you have heard it? Kidding. All right, we're going to do 7 questions today, and there's not many of us who are joining, but I'm hoping you have a chance to enter your answers in the chat. This is just for fun, and it's kind of to point out some of the gaps in our knowledge, because most of what we know we get from TV when it comes to the law. And later, I'm going to be sharing some real life stories with you tonight. But for now, let's try the quiz and see how far we get. So type your answers in the chat, true or false. And again, this is just for fun. All right, 7 questions, round 1. If something happens to you, your business keeps running while your family sorts things out. True or false? Don't be shy. Come on. All right. We got some good answers. Keep coming. And the answer is, very well, false. So unless somebody has documented authority to carry on, to sign for you, your accounts will be frozen, your payroll will stop, vendors will go unpaid. Not even your spouse or partner can sign for you without a court order. So this means your business could be in weeks of limbo until a judge appoints a conservator. And so 20 years of a business value can be lost in 60 days. And it's not because you have a bad business, it's because nobody could legally run it. Okay, round 2. Your business succession plan and your estate plan are separate things. What do we think? True or false? All right, mostly trues here. And the answer is false because they need to be built to work together. We need to look at your operating agreement and the trust, because if those two conflict, then you're back in conflict. So a family and business partners often end up in court against each other because those two documents conflict. The plan didn't just fail, it actually created the fight. So that's why tonight we're going to talk about both your personal estate plan and your business succession plan, because they work together. Okay, round 3. A power of attorney lets your spouse or whomever you choose handle your affairs after you die. What do we think? True or false? Mixed here. Okay, I'm seeing both. The answer is false. And that is because a power of attorney dies when you do. Now, a power of attorney helps for somebody to step into your shoes if you're incapacitated, but it does not help you after you die. That's also what we're going to be talking about tonight. Families usually learn this the hard way when they're at the bank counter at the worst possible moment. So this is a big one. Ooh, Brian, 0 for 3. Sorry, buddy. Okay, question 4. If you have a will, your family avoids probate. What do we think? True or false? This is a hard one. Okay, all right. This one is also false. A will does not avoid probate. It's really just an instruction manual to the judge telling the judge what you wanted. But if you have a will, you still need to go through probate. That is, if you have over a certain level of assets, which we'll talk about later. And probate, by the way, it's a court case. It's basically you filing it against yourself for the benefit of your creditors after you've died, because your creditors get paid first. It can last 12 to 18 months in California, and it's completely public. So your affairs are completely public if you go through probate. Anybody can read what you own and what your family's fighting about. And by the way, your assets are frozen until the judge releases them. So this is something you definitely want to avoid. What about the mighty trust? If you have a trust, your family does avoid probate. If you have a trust, your family avoids probate. True or false? Okay, Tony, good. All right. This is mostly true, but there's a big if here. So a trust allows your assets to pass without a judge's order, but only if your assets actually make it into the trust. And this is one of the biggest mistakes and gaps I see in planning. So think of a trust like a treasure box. It creates the container to hold your assets safe. But the trust is only the container. If you put nothing inside it, the trust is useless. It means nothing unless the assets are actually placed in the trust. Most law firms, for example, stop at creating the trust. They create the trust. At my firm, we help you create a complete asset inventory from the beginning. So whoever needs to step in for you knows exactly what you have, exactly where it's located, how to find it, how to access it. And we also give you complete guidance to make sure your assets make it into the trust. This is what we call funding. Because if your assets don't make it in the trust, what happens? You're back to probate court. Same process. So that's why this is a big deal. And it's a big if. Just this week, as a matter of fact, I had a client come in and his last attorney retired a few years ago. So he came in to see me. His trust was 10 years old. And I found out that 5 of the 7 assets he had were actually not in the trust, and he had no idea. You might think that this is malpractice. It's not. It's common practice. And it's another reason why bargain or DIY plans often fail. All right, we're getting to the end here. Round 6, 2 more to go. If you leave your children their inheritance in a properly structured trust, it can stay protected from their future divorce or creditors even after they receive it. That one's a little complicated. Can you protect your children's inheritance from their rotten divorcing spouse or their creditors? Ryan knows the answer to this one. This one is true. Yes, you can protect your children's inheritance with a properly structured trust. Let's face it, you probably didn't like your kid's ex-spouse anyway. So let's make sure that your inheritance never goes to your children's spouses in the event of their divorce. We can also protect their inheritance from lawsuits against them, creditors. Most families never structure their trust this way because nobody told them it was available. And you're not going to find this in a $600 LegalZoom trust, I can promise you that. It needs a real conversation with an attorney. But it's a huge gift that you can leave them, asset protection. So if this sounds interesting to you, if you pulled up that sheet, and there's a link in the chat, if you pulled up that worksheet, you can scroll down and check the box that says you want asset protection. So that'll let me know that this is something you're interested in. Last question. Now I'm talking about your kids, the little ones. You're out to dinner. Your kids are at home with a babysitter. You don't make it home. Your children go to your family. True or false? True or false? That's right. This one is false. If you have not named legal guardians, your babysitter has no legal authority to hand your kids over if you're not there. They don't have authority to make medical decisions for them. They don't have custody. A will may name guardians long-term, but it doesn't cover those first critical few hours if nobody can find the will, if temporary guardians aren't named, and if there's nothing documented that you can give the first responders showing who has legal authority to take your kids. So they often go in the care of strangers in those first few hours. That's why we offer a kids protection plan to every family I work with, where we name guardians. We give all of those guardians letters and the legal documents they need to act fast if they need to. And I also give you wallet cards that you can carry in your wallet so a first responder knows exactly who to call and who has the legal authority in what order. So that is a great thing for your family. And again, if you pulled up that worksheet, check the box if you found a gap in your planning that you want to ask me about. And I think the box says, I need a kids protection plan to name legal guardians. All right, so that's my game for tonight. Let's get down to business. If you do not have an estate plan, you actually do have an estate plan. It's called the probate code, and it's California's estate plan for you. That is the default you get. So in this situation, if you end up in probate court, or if you're incapacitated, you might end up in conservatorship court. Same thing, different situations. Your assets will be frozen. A judge who doesn't know you will be charged with making decisions for you and your family. They're going to be going through this process for 12 to 18 months when they're still trying to grieve or when they're trying to deal with whatever is going on with your family. They can't sell assets. They can't sign for you. And everyone gets paid first out of your money because probate has lots of fees attached to it, automatic fees, attorney's fees, executor's fees, appraiser's fees, court fees, creditor's claims, and bond premiums. So that's why it all adds up. So what exactly goes through probate? It's these assets. And some of you may be asking why I have life insurance and retirement here, and I'll get to that in a second. But if you own real estate, and if the value of your home is worth over $750,000, that's not the equity, by the way, that's the value of your home. In this community, that's not even a starter home. So if you own your own home in this community, chances are it's going through probate if you don't protect yourself. Bank accounts and investments in personal property or securities over $200,000. Business interests, if you don't have a succession plan, all of that goes through probate. And for retirement and life insurance plans, yes, those do get paid on death, except if you have not designated anybody as a beneficiary on those accounts, or if you've designated your young children, or if the person you designated has died, then you bought them a ticket to probate court too, because those assets will also wind up in probate court. So if you fail on those designations, then those assets also go into probate court. So probate costs about 4 to 7% of the value of your estate. So right now I'm going to test your math skills. If you're driving, don't pull up a calculator. But if you can, pull up your calculator app, because we're going to do some quick calculations to see what your estate looks like in probate. So I want you to calculate the fair market value of your home, add in any bank accounts, investment accounts, add your personal property, cars, boats, art, jewelry, whatever's in your house, make an estimate, Add the value of your business if you don't have a succession plan. And if you've named minor children or your designated beneficiary on your forms is dead, or you don't even know who's on your forms, add that back in for your retirement accounts and the value of your life insurance policies, because those will go through probate too. So add all that and then multiply it by 0.05. So 5% is a conservative estimate. That's how much the court will take out of your estate to pay for probate. That's money that your family could have received. And if all that's too complicated, let me give you some simple quick math. If you died yesterday with a $1.5 million house, that's a basic house in our community, and say $300,000 in assets, that's a $1.8 million estate. Multiply that by 0.5, and it costs your family $90,000. That's $90,000 that you worked for that they're not going to receive. And if that blows your hair back, you're not alone, because this is a huge reason why estate planning is so important, and why spending a few $1,000s up front to get this done right saves your family tens of thousands of dollars on the back end, not to mention 12 to 18 months of misery, no fighting among your family members, and countless hours of their time. It is a mess. So if you do not want to leave a mess for your families when they're already grieving, if you don't want to leave a mess for your family when they're already grieving, and you want to avoid probate, pull up that form again and check on the form at the bottom. I need to avoid probate by creating an estate plan. So let's talk a little bit more about what goes into a comprehensive estate plan. And this is on the personal side, and in a few minutes, we'll turn to the business side. On the personal side, an estate plan consists of a will. Most of you know what that is. A trust. We talked a little bit about that, but we'll get into it a little more. A power of attorney. And remember, the power of attorney is for incapacity, not for death. A healthcare directive. That's a document that says who can make medical decisions for you if you can't speak for yourself. Again, this is an incapacity document. And the kids protection plan that we talked about, which is naming both permanent and temporary guardians and all the documents they need to make decisions and to care for your children if something happens to you. So those are the basic documents that go into a comprehensive estate plan. Getting more into the weeds on wills versus trusts, because I want to explain this a little bit more. Now, both say what happens to your assets after you die. So if you and your spouse die tomorrow and you have just a will, again, that will be filed in the probate court, and the judge will determine how to distribute those assets based on your wishes. And if you create a trust, and again, if your assets are placed in that container, in the trust, your relatives don't have to go through probate when you die. A trust is essentially a legal contract where the grantor, who is you, gives assets to a trustee. The trustee is also you until you die. And then another trustee steps in for the benefit of your beneficiaries, which are your heirs. So again, a trust is like a treasure box. Who has the control over the treasure box while you're alive? You do. It's revocable. So you can change it, amend it, do anything you want with it. You put your assets in the box so they're no longer technically yours, and they're held there, but you're in control. If you drop that box, everything stays inside. And so your chosen person can pick it up and carry it for you. You make all of the decisions when you create the trust. And the key to remember is that the trust is the box. The assets need to go inside it, and this is called funding. It requires your assets to be renamed so the trust owns them, and that's how you avoid probate. Creating the trust is the first step. Aligning your assets is the next important step, and this is where, again, we see a lot of trusts fail because they didn't put their assets inside. In my practice, we have systems in place to make sure that this doesn't happen. So let's put some real life stories behind this. I've changed her name, but my friend in this community in Solvang, her mother died and she was made the executor. Her mother had a will, so she was made the executor of the will. Her asset, she had about $1.5 million in assets. And because she had a will, but not a trust, a probate case was started. There were also some step siblings that were really pissed off that she was the executor, so they fought her tooth and nail. This probate took her 18 months. I watched her go through the stress of it. All the assets were frozen. Nobody got anything until the process completed. And to this day, she does not talk to those step siblings. So a family was fractured because of it. Now, Melanie's mom had good intentions, but if she had come to me, we would have put her house in a trust and all of this could have been avoided and her family would have saved $75,000 in fees and costs. How many of you have heard a similar story? Let me know in the chat if this sounds familiar to you, because a lot of people don't realize this is what happens to their family if they don't create a trust to protect them. And what about asset protection? We talked a little bit about this in the quiz. What's great? Oh, I'm sorry, Tony. I see. Yes, exactly. So what's great about trusts is that when you die, you can create varying levels of protection for your beneficiary. So trusts are built for asset protection. The type of protection depends on exactly what you want. And these are decisions that you can make in the planning process. You can decide when your kids get access to the funds, because by the way, if you have a will and your kids are 18, they get all of that money outright, lump sum right in their laps. So with the trust, you can spread it out a little bit and let them build competency in handling money before it's put in their laps. You can also create protections from lawsuits, creditors, gambling debts, and as you know, my favorite, ex-spouses. So your assets stay in your family when they get passed down. When you sit down to meet with me, we design what level of protection that you want. Because remember, if a child turns 18 and they inherit your life insurance policy, what do you think they're going to do with it? Do you think they're going to invest it wisely? What's an 18-year-old going to do with $1 million in their lap? Right. So you can guarantee that things get structured properly and we can build in competencies so they can be the trustee of their own trust fund. Yes, we will create smart trust fund babies. They will be competent to handle those assets. So all of that is worth a conversation. Okay, the next thing that an estate plan covers, and we talked a little bit about this, is your incapacity. So who makes decisions for you if you can't speak for yourself? If you're in a coma, if you have a mental illness, we're talking about when you're not there, you're physically present, but you're not able to speak for yourself. And there's two documents here that are really important. The first is a durable power of attorney. That says who makes financial decisions for you. Once that power of attorney kicks in, usually when a doctor says that you're incapacitated, once that power of attorney kicks in, then they can sign for you. The other is a healthcare directive, and that says who gets to make medical decisions for you if you can't speak for yourself. What's important to remember here is that these documents do go stale. They need updating every few years because if they're too old, the bank won't accept them, the hospital won't accept them. So they need to be updated every few years. That is why when you work with me, I build in annual free plan reviews every 3 years. We will revise these things. You meet with me, we figure out if your decisions are still working for you, and that's how we make sure that your trust and your estate plans stay up to date. And now I want to tell you a real life personal story. This happened to me. It's a little difficult to hear, but I tell it because it's important to remember why this matters. That's my mother, Marlene. And her story is the best example I can think of where this really makes a difference. When I was 13, my mother, my brother, and we were in a hiking accident, and my mother had the worst injuries. She actually broke her neck. While she was unconscious, the doctors gave my father a choice. Now, they didn't have to. They could have forced him to go to conservatorship court. So it depends on the hospital sometimes. But they gave my father a choice because she was unconscious. They would either turn off the ventilator and he could choose to let her go, or he could keep the ventilator on and she would live as a quadriplegic, unable to breathe and walk on her own. Now, my parents never had the conversation, and she didn't have a healthcare directive because if she did, her wishes would have been honored. So my father didn't want us, me and my brother, to lose our mother, so he kept the ventilator on. And for a year, my mother lived as a quadriplegic until she decided that she no longer wanted to live that way. And she starved herself. She refused food for 45 days until she passed away. Now, I know that this is a scary story and it's tragic. And I tell it because tragedy can strike when we least expect it. But that year of her suffering could have been avoided, the conflict, the guilt, the trauma, all of it. And her wishes would have been honored if they had simply been written down. You can imagine that this experience is at the heart of why I do what I do. Because to me, estate planning is not about documents. It is about love. It's about protecting the people that you love most from having to make impossible choices like this. And it's about ensuring that your voice is heard when you cannot speak for yourself. So if this story helps you understand why this matters, I want you to check on your worksheet. I need to make sure my wishes are honored and my family is cared for if something should happen to me. Okay, now let's move on to one more important part about estate planning. And this is for those of you who have young kids in your home, and we'll also talk about people that have older children who are maybe 18 college years. So how many of you have children still living in your home? I do. My kids are in high school. Well, my youngest is starting high school in a couple of weeks. Great. So a comprehensive estate plan also considers how your loved ones are cared for. If you have minor children, if you have special needs adult children, naming a legal guardian is so important to give the person that you choose the legal authority to care for your children if something happens to you. And in my practice, we spend a lot of time on this. That's why the Kids Protection Plan is so important, because we create those documents for you and we give everybody letters so they can step in, so everybody knows what to do, and your children will never end up in the care of strangers. Now, 70% of families have not named legal guardians. And if you or your spouse don't make it home one night, what happens to your kids is they could likely end up in the care of strangers. So until a judge can decide, and usually this takes about 72 hours, your family doesn't get to step in automatically. It has to go through a judge. Also, with a kids protection plan, we can make sure that the person that you want will raise them. So if you have that weird Uncle Bob that might step in to ask the court to care for your children and you never want weird Uncle Bob to care for your children, we will create a confidential exclusion so Uncle Bob never takes your children. And I have one more story that shows why this matters. And this happened to my best friend, Holly. So Holly married somebody who was a widower, and she had a stepdaughter who was just a couple of years old and she helped raise the stepdaughter. I think the stepdaughter actually was 5 when the father, who had some mental illness, committed suicide. Now, Holly went to court to fight to care for her stepdaughter, but the judge was not convinced, and the judge awarded custody to her husband's mother. And Holly was convinced that her husband never would have wanted this. She knew, but they hadn't named legal guardians. So the judge had no idea what the husband's wishes were. So despite all of her best efforts, she was cut off from this child until the child turned 18 and they reconnected on their own. And now the child has 2 twins of her own, and Holly's in her life again. But those were 13 years that she did not get to see the stepdaughter that she helped raise. That's why this is important, and that's why this matters. So if you're part of the 70% who hasn't yet named legal guardians, check on your form. I need a kids protection plan to name legal guardians. Okay, so we've covered what goes into your family's estate plan and why it's important and where you may have some gaps that need to be filled. Now I'm going to turn back to your business, because the first 5 documents talk about your family, but that alone won't protect your business or keep it running. So this is how you keep your business running without you. Business owners need a few more documents in their arsenal. First, we're going to look at your succession plan. A lot of times this is in an operating agreement or it can stand alone. Your succession plan states what happens to your business if you retire, if you're incapacitated, or if you die, who can run it, and how it keeps running. So if you haven't looked at that operating agreement since day one, since you put your business in place, now would be the time to take a look at it. So we want to make sure that your succession plan for your business communicates with your estate plan. That way they work together, there's no inconsistencies, and your family doesn't end up fighting your business partners in court. Next, we're going to assign the equity in your business to your trust. That way your family can continue to benefit from the money that's flowing into the business. So without that, all of the assets just stay in the business. You need to assign them to the trust so it flows through the trust when you're gone and your assets get distributed the way that you planned. And if you want one child to carry on the business, but maybe other children don't want to carry on the business, we can consider that. And we can figure out what non-business assets the other child might take. So this, again, warrants a conversation because we can equalize the share if you have one child that's interested in taking over your business. If you have partners or investors, we need to make sure that there's a buy-sell agreement. This states what happens to the partnership, who buys out who if something happens. And we make sure that if you are incapacitated or you die, the buy-sell agreement gets funded with life insurance. That way, if something happens to you, it automatically gets paid out. Your family now gets the beneficial interest from the business, or it's paid out to your partners and they get that payment. And the business can keep running without you. So it's all funded with life insurance. It's a really neat plan. So that is how we take care of your business. And that is how we make sure that your business is working together with your estate plan so your family continues to be protected. Okay, so we've named all the gaps and we've talked about the cost of not planning. So yes, I am aware that you can create plans on AI now. You can create plans with LegalZoom. You don't necessarily need to work with an attorney. Financial planners are offering them, but none of them are going to be asking you questions. None of them are going to have attorney-client privilege. None of them are going to be on the hook if something happens to your plan. That's why I have malpractice insurance, because I need to make sure the plans that I put together are legally sound. So you sign away all those waivers when you go on LegalZoom. A financial planner they're not asking you those questions. This is the relationship. This is why lawyers do what they do, because we are the ones that can handle this for you. You can get it done elsewhere. It's not necessarily a good idea. So I also designed custom plans that are built for your family, not cookie cutter templates. We have the free plan reviews, so we make sure that the things change. You know, your decisions are going to change. Your family dynamics are going to change. The law is going to change. Your assets are going to change. So we're going to be reviewing that plan with you every 3 years to make sure it's still working for you. If you buy a new home, we will make sure that it's still working for you. And if something happens to you, your family will know who to turn to. They will have a relationship with me because you've created that relationship. That's why you want to work with a personal family lawyer. So we've identified the gaps in your existing situation, and now I'm going to share with you how you close those gaps by creating a plan that protects your family and your business. So this is how you work with me. I offer 3 levels of planning. You'll see the fee range on the screen. And the fee range is because you actually choose your fee based on what's important to you. So you'll meet with me, you'll make some decisions, and I'm not going to sell you anything that's not important to you. So that's why there's a range there, and you get to choose what's important to you and what your fee is. I start every client relationship with a life and legacy planning session. That is a 2-hour working meeting with me where I'll review I'll review your plan, your existing plan. Or if you don't have a plan, I'll review the state's plan with you so you know exactly what the numbers are. We'll look at your family dynamics, your assets, your business. I'll lay out the options and we'll work through them together based on what's important to you to create a custom plan that fits your family and your business. Now, normally, the life and legacy planning session, it's 2 hours with me, costs $750. However, if you're willing to do a little homework in advance, and that homework is filling out your family profile where you tell me about your family, what you own in your business. That way I come to the meeting prepared to discuss your situation so I can help you. If you do that homework in advance, I will waive the fee entirely. And for tonight, if you schedule your life and legacy planning session with me tonight and you show up to your appointment with your spouse if you have one, I will also gift you $250 towards the plan of your choosing. So that's $1,000 in legal fees back in your pocket just to take action tonight. And the reason that I'm doing this is because I know the biggest risk to your family is that you leave here and do nothing. And I hate getting the calls that something has happened and now it's too late to plan. Those are my worst days as an attorney. So you came tonight to get educated. Thank you for showing up. You came tonight to get educated on what it takes to do right by your family and your business. So I am throwing money at you to motivate you to take the next step. And I will do my best to make it as easy as possible from there. So here's your next step. There's the QR code again, and then the link again that Caitlin posted to pull up the worksheet. finish filling out that worksheet and submit it to me. Give me comments on the presentation today. Let me know how you found it. Submit it to me and we will reach out. And if you want to take advantage of the $250 credit, I'm going to put another link in the chat right now. Here is where you get on my schedule. This is how you book the life and legacy planning session with me. So don't kick this can down the road because I can only work with a few clients a month. I've got 2 spots left in August and I've got a handful in September. This work is labor intensive, so that's why I can only work with a few people a month. So book your session with me tonight and you will earn that $250 credit when you show up. It takes $100 to book the session. That is your commitment to showing up. It's just a deposit. I apply it to your plan. So it's a $100 deposit to book your session with me. If you already have an estate plan, by the way, just a little more housekeeping. If you already have an estate plan and you want it reviewed or you want it double checked or your attorney retired like my other client, that's a little bit of a different track. I need to get that plan in advance. So if you already have an estate plan, just turn in your worksheet and let me know and I will get in touch with you and explain how that works because it's a little bit different. But if you are new to estate planning, use the link and you can book your session with me. And that's all I have for tonight. We've got 15 minutes for questions. If what I shared with you resonated and now you understand why it's important to plan, I want you to get on my calendar while it's still fresh in your mind. So thank you for spending time with me tonight. Thank you to the Solving Chamber for hosting this event. And I look forward to getting to know you and your family better as your personal family lawyer. Thank you so much. So I think we can turn off the recording now if anybody has questions. If you do have questions, like I mentioned, the